Welcome back to Sunrise Daily. Well, we'll turn our attention, continuing as a matter of fact, first and foremost with the Code of Conduct Tribunal. Yesterday, we heard the proceedings yesterday, but now we're joined by Honorable Razak Atunwa, who is a member of the APC. He joins us from our studios in Abuja. Morning, and thank you for joining us. Well, yesterday was a day that a lot of focus on 80 senators showing solidarity, and I'm sure members of the House of Reps also went in to see what was going on. Tell me, what's your impression of this entire proceeding?
Well, good morning, Timberlane, Sulaiman, and yes, we went to the Code of Conduct Tribunal to accompany the Senate President. He attended at the scheduled then legalized suit was the prosecuting authority, CCB, Bureau. Then, yeah, based on this pending judgment. Or two pending that judgment being given by the Court of Appeal. So, consequently, the Code of Conduct Tribunal then adjourned the matter.
I think we may have to do some corrections because right here in the studio, I missed out on a lot of what you've said. But there are many who are suggesting that there seem to be some political motives to this trial. Do you subscribe to that view?
Well, I have to, as lawmaker and a person who is learned in law, some sort of beyond what is apparent. What we do know is that these are charges that stem from 12, 13 years ago. Charges, and the Senate President is to be a governor in the last 5 years. Why would he have taken 5 years to come up with his charges? His Code of Conduct forms have been with the Code of Conduct Bureau for all that period of time, stemming from 2003, when he assumed office as a governor. He left office in 2011. Now, one asked the question, why was the prosecuting authority dilatory in this prosecution? Why were they dilatory in presenting charges or preferring charges? That's the first thing. But we do accept that charges can never be, or an offense or the legality of this nature, as it's alleged, cannot be antiquated. But still have to ask the question, why wasn't it brought in good time? Then you ask yourself, why were there so many breaches or procedural breaches in preferring these charges, which is what effectively gave rise to the Court of Appeal proceeding. The application was first made before the tribunal itself, and the tribunal rejected it if I may describe it, in a wanton manner. And consequently, the defendant then had to apply to the Court of Appeal to reverse that ruling. There was a plethora of breaches and violations of procedures and laws which gave rise to this judicial review of Conduct Tribunal's actions, and indeed the CCB's actions.
Let me try and understand what you're saying. Are you suggesting that because it happened a long time ago and not now, they shouldn't have brought it up now?
Not at all. As I said, charges are not antiquated. There's no time bar in matters of this nature. But one has to ask oneself, why would it take such a long period since the person had left office? Why would it take such a long period before preferring charges? You had the forms there all along. The forms never went anywhere. And if you believe there was something wrong in his forms, in the manner in which he declared his assets, then first of all, the first thing you ought to do, in accordance with the, and perhaps let me get some of the argument, the first thing you ought to do, in accordance with the Code of Conduct Bureau and Tribunal Act, Section 3D, is that you invite the person to say whether or not he had failed to declare a particular asset or didn't comply fully with the declaration of his assets. Now, Section 3D says this of the Code of Conduct, Bureau and Tribunal Act, It says, which is the functions of the CCB, it says it has powers to receive complaints about breaches or non-compliance of the Act, that is to say, declaration of assets. But interestingly, it says, provided, this is the key point, provided that where the person concerned admits that he had failed to comply with those provisions, then there shall be no reference to the Code of Conduct Tribunal. In other words, you invite the person, look, we've got your form, you didn't declare X, you declared Y, but you didn't declare X. Now, is it the case that you own X? If he admits that, yes, I do own X, but I forgot to declare it, or for some reason or other didn't declare it, or didn't think I needed to declare it, for whatever reason, if he says, yes, I own property X, for example, and I didn't declare it, the provision says there shall be no reference to the Code of Conduct Tribunal. The essence of that is it's not a punitive measure. You're trying to get the person to declare his assets. Now, if you observe a lapse, you bring it to his attention, he accepts that, yes, there was an error in that declaration. By so doing, that person has accepted that that property is his or hers, and by so doing, that person has henceforth declared that property. The question would come if I, for example, you challenge me that do I own property X, and I say, well, I don't own property X, and you as a Code of Conduct Bureau have evidence that I own property X, then of course there's a difference between myself and the Code of Conduct Bureau. Then there can be a reference to the tribunal. But once the person accepts it, then there can be no reference, so there's no issue to be tried. So that's the first breach that occurred. One of the other breaches in terms of preferred discharges is that these charges were preferred by a deputy director in the Federal Ministry of Justice. The Code of Conduct Bureau Tribunal Act, particularly Section 24, subsection 2, says that the prosecution of offences under this Act shall be instituted in the name of the federal government by the Attorney General of the Federation or any person so designated by the Attorney General. Now, we all know that since we came into power in May this year, no Attorney General has been appointed. So where did this person get the power to sign or prefer charges to the Code of Conduct Tribunal? So again, that's a flagrant breach. These are the matters which have been raised in the Court of Appeal. And there's a final one for completeness. The jurisdiction of the Code of Conduct Tribunal itself is a question. It is not being properly constituted. Now, Section 20, subsection 2 of the same Act, the Code of Conduct Bureau and Tribunal Act, says quite clearly that there shall be a chairman and 2 other members. At the moment, you only have 1 chairman and 1 other member.
So those are some of the priors before the courts now. So maybe until when that is determined, then we'll then know where next to go. But some of the issues you highlighted here in terms of they've had the form all along, why didn't they look through it, and why is it popping up now? Many may impute some motives, maybe political if you will, but is there something that you may be willing to suggest to the House of Reps, or should National Assembly also look into those kind of matters by way of, say, public hearing with a view to ensuring that this kind of things don't happen again? And the second leg of that is, would it be out of place for the National Assembly, maybe Senate or House of Reps, to say, okay, in order for us not to have cause to say, look, this is politically motivated, let everyone just make this asset declaration public. Let everybody see it, so there'll be nothing to hide.
Well, dealing with the first leg of your question, the law is quite clear, the Constitution is quite clear, and the law is quite clear. The Code of Conduct Bureau and Tribunal Act is quite clear. In as far as we amend that, I believe that the matter in court, the Court of Appeal can settle this matter very quickly. And I believe the justices of the Court of Appeal are eminent enough to ensure that there's a settlement on this matter. So I, for my part, do not see any great need for the House of Representatives or indeed the Senate, the National Assembly, to begin to amend the Act, because I can't see where it's faulty at the moment. But of course, I can bow to superior argument if someone can show me where the Act is faulty. But it's the operation of the Act. It's how we conduct ourselves in line with the law. You see, we have to get away in this country from riding roughshod over people's rights. We have to get away from in this country from cutting corners. In law, the substance is just as important as the form, because justice must not only be must not only be done, it must be seen to be done. Now, if the law stipulates certain steps to be taken before you arrive at your destination, if you arrive at that destination without going through those, then that's fault. That's the corruption of the process. So, in as far as I'm concerned, the National Assembly need not weigh in into amending or have a knee-jerk reaction to seeking to amend the Code of Conduct Bureau and Tribunal Act. The second limb of your question, if I get you correctly, is beyond that, what is it that we need to do in order to ensure that politicians are not seen as corrupt? Do we need to ensure that assets are declared publicly? Well, that's a matter for public opinion. If it's a strong move, I am not averse to it at all. If there is a strong move by the public, if there's a need by the public to say, like, everybody should declare their assets, indeed all politicians holding public posts should declare their assets publicly, then of course we will have to comply. If you have nothing to hide, as far as I'm concerned, there is no issue if the law compels you so to do. But at the moment, the law doesn't compel you so to do, and then anyone who declares to the Code of Conduct Bureau, of course, has complied with the law. And I think the reason why, just thinking out loud, the reason why at the moment the law hasn't compelled politicians who are public posts to declare their assets publicly is that we at the moment live in an environment where there's a great deal of skepticism, imputation of bad motive, and all sort of denotations.